Well, I think that I find it quite intriguing to start with that the acting chief justice himself will decide where the proceedings, and as I indicated, I find it very incongruous because indeed, if at all there's any beneficiary from all of these developments, it is the acting chief justice is a direct beneficiary of this. Of course, it's a constitutional injunction for him to act as the next senior, but clearly we cannot lose sight of the fact that whatever has happened is beneficial that goes to him. And it is incongruous in the constitutional history of this country. We've never seen any development like that before. Whenever there's a dispute as to the state of the chief justice in this country, start from 1980 to 419, start from 1983, 94, happened, and we go to 2005, there about Gaewu and all. The chief justice in question panel the court, but never sat on the matter. I mean, so it cannot be right for the acting chief justice to sit on the matter. But that's it. You will see the 3-2 ruling, very narrow decision. We'll wait for the reasons. When the reasons come, we'll definitely advise ourselves. The narrowness of the decision itself indicates clearly that the application, no doubt, had merit, and we know what to do. All right?
Your main argument, your final word, relates the timeline.
The reasons for the decision have not been known. Of course, clearly, I mean, the spirit of Article 146 we're talking about. In the first place, it is important to indicate that nowhere in Article 146 will you find a requirement for prima facie determination made for a chief justice. But the Supreme Court itself imported that into Article 146 in 2005 when it authenticated on the Gaewu matter. But of course, the Supreme Court was silent on whether there ought to be notification to the chief justice and obtaining of his or her comment before triggering the process. And that is what is in dispute before the courts. My contention is that natural justice, all the rules of constitutionalism and all will require that there ought to be such process before Article 146 can be triggered. Thank you very much.
All right.
The Supreme Court has spoken, and I think on the 21st of May, we will get the impulse of the reasoning behind the ruling, and maybe from there we will be able to decide as to the next course of action.
So you wouldn't say this is the end of the road?
Well, I don't think this is the end of the road, but let's just get the reasoning first. When we get the reasoning, of course, the 3-2 ruling suggests that the Supreme Court itself sees some reasoning in the arguments that we made in court. It tells you that our argument or the reasoning that we advanced in court was quite potent. And so let's get the reasoning, and when we're able to get the reasoning, we'll be able to decide what we intend to do after assessing the reasoning.
What do you make of the fact that your counsel couldn't point out to the provision that clearly states timeline within which the chief? How damaging was that to your case?
Well, I was even surprised that it even came up because 24 versus Attorney General clearly tells you that in reading the Constitution, you have to do so by the letter and the spirit. If anybody tells you that because something has not been clearly stated in the Constitution, and for that matter, it has no potency, I am telling you that that is not the case. In fact, even today, the Interpretation Act of Ghana tells you that we have to read the Constitution purposively. Purposively means that the letter and the context is very much important. It is on that basis that even the Gaewu case, where a prima facie that will have to be established in the case of a chief justice, which has not been stated clearly in the Constitution. Gaewu said that we have to establish a prima facie. So if anybody tells you that something will have to be stated in the Constitution before some potency will have to be given to it, I don't think that is a law. Let's wait for the reasoning and see what we can do.
Are you disappointed with the...
Well, I disagree.